You're muted, Erica.
Thank you, Jeremy. Welcome everyone today to our webinar, Handling Multiple Offer Situations. We are asking that you submit your questions throughout the webinar. We'll be taking them well, not as they come, but we will be taking them at the end of each topic section. So please use the chat and select all presenters to send your questions, and we will, and I'll be sharing them with the presenters. If you have any technical issues, please call the tech helpline at 888-804-8226. Remember, that is a free member benefit that you can use anytime you need tech help. If you are for CE credit, if you've registered for this webinar, which means you're here, then your CE is being processed. We'll send an email out where you can find it in your Oregon Realtors account after this webinar. So thank you. And with that, I'm going to kick it over to Jeremy, our Director of Legal Affairs.
Hey, Erica, thank you so much. And Erica, thank you for all of the work that you have been doing over the last year, putting on these webinars for our members, and hopefully today will be as successful as the previous ones. I did see someone in the chat mention a feedback issue of asking if other people were experiencing feedback. I don't know if that was an isolated incident or not, but just FYI. So everyone, welcome today to our webinar on navigating multiple offer situations. With the historically low inventory that we've seen over the last year, we know that this has been a hot topic for quite some time, and an area where Oregon Realtors are looking for best practices and guidance. And fortunately today, we have two experts with us who can lend their experience and expertise to this subject. Let me go ahead and introduce them. And as Erica mentioned, I'm Jeremy Rogers, the Director of Legal Affairs here at the Oregon Realtors. And one of our guests today is Deborah Gisrael. She is the Oregon Managing Principal Broker for eXp Realty. Deborah was the 2019 Realtor of the Year in Oregon. And Deborah has over 40 years of real estate experience and a plethora of real estate designations, demonstrating her professionalism and her commitment to continuing education. She's been heavily involved at all levels of the Realtor organization at the local, state, and national level, including serving as the 2013 president of the Klamath County Association of Realtors and the 2016 president of the Oregon Realtors. Deborah also serves as an instructor for the Oregon Realtors Principal Broker Academy, where she teaches other principal brokers about risk management and related topics. Deborah, thank you so much for being here. We're so fortunate to have someone with your level of expertise to help us navigate this tricky topic.
Happy to be here.
Our other guest today is Janet Grayson of Grayson Law, LLP. Janet is a partner in the firm's real estate, business, litigation, and estate planning and probate practice. Janet provides services in all aspects of real estate, business, probate law, including planning, transactions, licensing, probate, mediation, arbitration, and court matters. Ms. Grayson is a published writer and a continuing education instructor for the real estate industry. She co-authors monthly legal columns in numerous local, regional, and national real estate publications. Ms. Grayson's also a frequent lecturer to realtor associations and real estate brokerages, and is an adjunct professor at Lewis and Clark Law School. Ms. Grayson practices in Oregon and Washington. Janet, it's a pleasure to have you, and thank you for all of the sage guidance and counsel that you have provided over the years to our association and to its members.
Thank you, Jeremy. Happy to be here.
Well, let's go ahead and get started. So today we want to cover a variety of topics related to handling multiple offer situations, including initial conversations with clients and preparing them for multiple offer situations, presenting and responding to offers, dealing with escalation clauses, buyer love letters and other buyer strategies for trying to stand out in the seller's market, seller terminations and remedies for buyers when sellers back out of a deal. So we'll also have plenty of time for Q&A, and as Erica mentioned, use the chat, and when we get to the end of a topic, we'll take questions on that topic. So let's go ahead and get started with some questions for our guests. So I wanted to start, Deborah and Janet, at the beginning, and that is agents preparing clients and themselves for multiple offer situations. So Deborah, let's start with you. Pretend that you are a listing agent and you're sitting down with a potential client. It's a hot market. You know that the seller is likely to receive multiple offers on their home. what is the conversation that you have up front with your seller? What should you discuss and agree on at the front end regarding how you and your client are going to handle multiple offer situations when they come up?
Well, that's a great question. And first of all, I'm going to assume that everybody's already doing a full, excellent listing presentation. And one of the most important things to do with your seller client is to inform them clearly and concisely of current market conditions and explain to them that there is the potential and the most likely occurrence of multiple offers, and have the conversation with them at the time you take the listing as to how they want to proceed, and to give them the negotiating strategies that are available to them and discuss those. For example, are they comfortable letting everybody know what everybody else's offers are? Do they want to keep it close to the chest? Are they willing to consider acceleration clauses? Those types of conversations. And the other thing that I recommend in this current market, and one thing I just want to stress here is that multiple offers is a market-driven occurrence. This too shall pass. And so I don't want everybody to get all upset that this is the new normal. It is not, and it will change. But one of the things I recommend when you are dealing with this market and talking to a seller is that once you've completed all your listing and you've gone through your dual agency and really explained that well, is I like to provide them with a copy of the purchase and sale agreement at that time. Because you don't want to be in a multiple offer situation where you're spreading out or showing them 5, 10, 15 offers and they've never seen that document. So I encourage you at the listing appointment with your seller is to provide them with a copy of that purchase and sale agreement, go over it briefly, but also give them an opportunity, as it says in bold at the top of the ORIF form. If you have any questions, please call Janet or seek competent legal advice. But what you've done is you've diminished the mystery of that document. And the second thing I recommend is if you are using a multiple offer tool like a spreadsheet, is that you provide that at the time of the listing to your seller client and explain to them, these are the key terms that we're going to be discussing when you get offers. Is there anything you'd like to add to this list? Are you comfortable with this list? And explain to them how that works as a tool, but that you will still be going over and in depth those offers in details. So that's one of the things that I do recommend in this market.
Great, thanks, Deborah.
Talking to a seller.
Yeah, thanks for that helpful info, Deborah. Janet, anything you want to add on sort of that upfront conversation with the seller's broker about multiple offer situations?
Yes, sure. So I certainly would echo much of what Deborah has said. You know, a large part of this is education of your clients, making sure you're setting them up for success and that they have realistic expectations as to how things will move forward, either on the listing or the selling side. What we've always kind of promoted over the years with, and this is not the first time we've been dealing with multiple offer situations and escalation clauses and the like. And so it will come back again once it recedes. But, you know, part of the education for your client is perhaps talking to them, you know, of course, about the protocols. And we've, you know, in the past have talked about, you know, providing a menu of the different options to your seller client about how to deal with multiple offers. And of course, there are a number of different strategies. You know, many brokers set with their clients' involvement, set a deadline for submission of offers, and then communicate that deadline to brokers through the listing, so that their client reviews all offers after a set deadline. Certainly, you know, some sellers will choose to review them as they come in. They may accept some in backup position. They may counter, one offer, or they may reject offers and, ask for highest and best by a certain deadline after they've started receiving them. And so having that conversation, setting the protocol, having the protocol in writing with your client so that you have your marching orders, so that there's no confusion down the road. And also explaining very clearly to your client that if you select one protocol up front at the time of the listing, you do not change course once you have started receiving offers. And I think that is, I'm not a realtor, but that is a very big challenge. And I hear realtors, complaints in that regard, that they've submitted an offer and they understand that the seller may have already accepted something before the deadline. And on the seller side, they're excited to sell their property and they may receive a really great offer and they want to accept that. They don't want to wait until that deadline. And that's hugely problematic, because guess what? You have the license. You're the one whose reputation is at stake. And turns out it's a small community, and making sure that you're clearly communicating, accurately communicating the protocol that your client has selected. And then as part of that as well, the protocol also needs to reflect what type of information your seller authorizes you to share with the other parties. And so are you sharing the terms of other offers that are being received? Are you, brokers over the years have gone out and shopped offers that they've received. It's not very popular, but it is something that's happened. And unless there's an agreement over confidentiality of a buyer's offer when you're on the seller side, you technically have the ability to do that, to disclose information from buyer's offers. And so having those instructions from your client is hugely important, and it will also help avoid problems down the road. And we see this come up in litigation, or have over the years, which is what informs a lot of the advice that I give to realtors now.
Great. Janet, thanks a lot for that helpful info. Deborah, I want to go back to you real quick on something Janet said. Both of you talked about the importance of having the conversations up front about disclosure of offers, how you're going to handle escalation clauses, love letters, other things. Janet mentioned putting it in writing. Deborah, any thoughts on that, on the role of putting it in writing?
Well, I think when you have that conversation with the seller, following up in an email with just wanted to confirm that this was the conversation that we had. There isn't a formal document or a form that accomplishes that. So I think just the simple follow-up email stating, based on our conversation, we've agreed that we're going to follow this protocol. And I think that will suffice for having your instructions in writing. Right. From a practical standpoint.
Yeah. And I think the confirming email is a great way to do that, and certainly something you do right away. And if your client has a problem with it, or it doesn't reflect what was discussed, or they've changed their mind, then they have an opportunity to respond to that email right away. Otherwise, you can move forward based on the confirming information that was sent in the email.
Yeah, absolutely.
Well, now I want to flip it, and I want to talk about if you're the buyer's agent, if you're preparing a buyer, and we know there's been a lot of disappointed buyers in this market. So if you know it's a tough market for buyers, and then homes are going for thousands over asking price with hot competition, many offers, when you're sitting down with potential buyer client before showing homes and helping them make offers, how should you best prepare the buyer for the competitive multiple offer market that they are entering? Deborah, do you have any thoughts on that?
Oh boy, you got 5 hours. Well, first thing is the same that I do with and recommend with sellers is that you have a very good, consistent with everyone because of fair housing, but that you have a very good and consistent, clear buyer consultation time with your buyer. And you use that, as Janet said earlier, you use that as a method of educating your buyer client on what to expect, and to make sure that their expectations are in line with what's happening in the marketplace. I think you need to take their temperature for risk reward when you're having that conversation, especially with some of the strategies that we're seeing now with with the appraisal gap and acceleration clauses and waiving inspections. I think those are three big risk areas right now in this market that we have to address. And I think you need to prepare your buyers before you even show them a home that these are the risks. What's your risk tolerance? And explain to them how very clearly how the counteroffer process works. And when there are multiple offers, they may not hear anything, you know. So I think that's probably the most important thing is setting the expectations with the buyer, explaining them, and how I teach it is, you know, explain to the buyer, here's what's going to happen. Then tell them when it's happening and explain to them what's happening. And then after it's happened, explain to them what just happened, so that you're reinforcing as you go through the process with your buyers, because they're gonna be in such a state of emotion, distress, that it's important that you keep them calm. And I find that that's one really good way to do that is to kind of keep them steady, keep an even keel by using that strategy. But
Thanks. I love that.
That's what I would add.
I love that advice, and the risk tolerance. I think it's so important, and also tell them what you're going to tell them, and then tell them what you told them. So that's great. Janet, anything you want to add on the buyer side?
Yes, so certainly, again, agree with what Deborah said, making sure that you're educating your clients, that they have realistic expectations. And then, the other thing that comes to mind, which goes along with what Deborah was saying, is that if your buyer client appears to have an appetite for risk and they want to use some of the riskier strategies in order to, gain an advantage or, sweeten the pot, so to speak, with their offer, making sure that they very clearly understand and appreciate those risks, and that you are advising them in writing through a confirming email, for instance, that you have explained that these are risky strategies. They have indicated their desire to incorporate or use those strategies as part of making offers on properties. And should they have any questions about the risks or the ramifications of using those strategies, they may wish to, consult with an advisor, legal advisor, financial advisor, and the like, just to make sure that you're covering yourself. Because, certainly the problem that comes up is that a buyer may think it all sounds great, and they may, be desperate to get a property, and they're using, all of the tools available to them. And they may have buyer's remorse down the road. They may feel as though they overpaid for a property. They may want to back out of a transaction once they kind of get over the emotional, the heat of the moment. They get their offer accepted, and they may regret it. And you don't want them to come back to you and claim that you were kind of walking them down this path. You want your documentation to clearly reflect that you had this conversation with them, that they understood and appreciated the risks attached to it, and made educated decisions to move forward in that regard.
Great. Janet, thanks so much for that. And I think one of the things both of you are emphasizing is the risk tolerance conversation, informed consent from buyers about anything they're going to do. And there isn't always a silver bullet on one way of doing this, but absolutely, if you're going to take on any strategies where the buyer might be at risk in order to put their offer in a better position, you need to really have a conversation and document that in writing, that folks know what those risks are, and people are making those decisions fully informed. I think a lot of times people are asking is this the right approach, or is that the right approach? And it might be different in every case, but in any instance, you always need to have the buyer be informed of the risks and make sure they're making that decision with all of the necessary information and reaching out to the professionals they need to. So thanks a lot for walking us through that, both of you. Erica, were you jumping in with something there?
Yeah, we've got a couple questions from the chat and some good ideas as well. So first question, let's see, it says VA or FHA buyer waives the appraisal on the offer. Then later the VA amendatory form arrives. And this could give the buyer an out if the property does not appraise or not. What about the EM? Can the buyer pre-waive the VA mandatory contingency?
Why don't we're going to talk about appraisal waiver
Okay, perfect.
specifically a little bit later. So maybe we'll hit that one when we get to that.
All right, that sounds great. Somebody else asked, will there be a form or forms to handle multiple offers?
So I think as Deborah mentioned, there isn't an OREF form on this. I know certain brokerages do have some forms that they might use for that sort of intake conversation when they first talk with a seller about how they want to handle the various aspects of presenting offers and escalation clauses and things like that. We do have some guidance on our website related to the topic as well. And as Janet and Deborah mentioned, a confirming email that hits all the topics that were discussed also can suffice. So, but there is not currently a statewide form for that.
Great, thank you. That's all the questions for this section.
Okay, great. So let's move on to the specific topic.
Jeremy, can I kind of quickly go back on the question regarding the VA and FHA loans? I think there's two things that this kind of falls back on the listing agent and the buyer's agent, that the buyer's agent should be working very closely with that buyer's lender and making sure that anything that they're writing in the offer or waiving in the offers is or is not going to impact that buyer's financing ability through the transaction, because I think that could borderline on misrepresentation. So you want to be clear when you're educating your buyer that you're going to be working with their lender to assure that. And then on the listing agent side, the listing agent, when they're reviewing offers, should have a good understanding of different loan requirements when they're instructing and guiding their seller on decisions that they're going to make. So I do think there's a mutual responsibility in addressing those questions, even in a non-multiple offer situation.
Yeah, great input. Thanks, Deborah. So let's talk for a minute about the specific issue of presenting and responding to offers in multiple offer situations. So we know that in this market, sometimes sellers are getting dozens of offers. We also know that realtors are required by state law and the Realtor Code of Ethics to present all offers, to document the presentation of the offer, and if the seller rejects the offer, to provide a copy of the rejected offer to the buyer. But we've heard concerns from buyers that buyers agents that they aren't sure that their clients' offers have been presented, and they aren't receiving confirmation from sellers agents about what happened with their offer. At the same time, sellers who receive 30 offers on their house would prefer to just let many of those lapse rather than rejecting them in writing. So what tips do you both have for sellers agents to help them meet their obligations around offer presentation and effectively communicate with buyers in situations where they may be receiving 10, 20, or 30 offers on a property? Deborah, you want to? Oh.
Well, first of all, communicate. Pick up your damn phones. Let's communicate a little bit here. But I believe that the listing agent has a duty and a responsibility to communicate back to everybody who presented an offer. You can do a template email that you send to all of the buyer's agents who presented offers. Let them know your offer was not accepted, and attach an initial rejection. You don't have to send the whole thing. You can do just the initial rejection showing that your offer was in fact presented. And the other thing is to, if there is a question as to whether or not your offer was presented, pick up the phone and call the other agent. I think and the other agents answer your phones or return your calls. I think the biggest complaint that I get as a managing principal broker is agents not returning calls. And, I don't think anybody's too busy to return a call. It only takes a brief time. That's why we're in this business. And so Janet, do you have anything to add to that? Because I don't want to get preachy here, but you
Sure.
know, I do
Yeah.
feel very passionate about this, that so much of this could be simply avoided by communication and doing the right thing and doing it efficiently. And please, you know, listing agents, let the buyers agents know that their offer wasn't accepted before it shows up as sold or under contract on MLS. You know, that's a heartbreaker. So, you know,
Right.
just be kind and treat the other agent the way you want to be treated.
Well, and it's,
Janet?
you know, there are certainly legal requirements regarding, you know,
Right.
presentation of offers and the like. And you know, I think, you know, most brokers by and large are complying with their legal obligations. The problem is that, you know, I hear from buyers and their brokers that they are they have concerns about whether their offer was actually presented, and how do we hold the listing broker responsible? Well, it's not their job, obviously, to enforce the law or to enforce the code of ethics. And if they have concerns, they can ask. But I think the upfront communication by the listing broker, acknowledging receipt, acknowledging that offers have been turned over or presented to the seller, and that an offer was rejected, even if the seller chooses not to formally reject an offer, letting them know is a professional courtesy, and professionalism goes a long way. And that's, you know, gets a little outside the scope of, you know, my practice as a lawyer, but I hear a lot of questions and concerns. And the last thing you want, especially in a circumstance where perhaps the listing broker has both ends, their buyer's offer was accepted by the seller, and that may be very legitimate. But the problem that comes up is that all of the other buyers feel as though there was perhaps an unfair advantage. So professionalism can really help to avoid those concerns to the extent they're avoidable, and at least, you know, communicate what's going on to the other side. And of course, you know, the code of ethics states that a listing broker, upon request from a buyer's broker, must disclose whether or confirm that the offer was presented to the seller. I think it's much better just to do that anyway, without waiting for a request from the buyer's broker, particularly in this market. You know, people are, you know, highly emotional about things, and it's much easier just to send out an email to everyone, you know, either individually or, you know, blind copy everyone an email indicating that offers were presented, so you don't have to wait for each individual broker to come back and request that information from you. It goes a long way towards avoiding problems, avoiding, you know, raising doubts in people's minds about whether you're doing your job.
Great. Yeah, great suggestions, Janet. And I did see that earlier there was a comment in the chat that's, I think, related to the offer presentation issue. And so I wanted to, and really around acceptance of offers, but I wanted to pose this to you, Janet. Let me read the comment first, and then I want to ask a question about it. So the comment is that many listing agents are setting a deadline for offers, and in the same breath state the seller reserves the right to accept an offer prior to the deadline. That really upsets buyers and confuses them as to whether it is worth even writing an offer. Now, earlier in your remarks, Janet, the previous question, you had mentioned the reputation of real estate licensees and how important that is, and to preserve your reputation as it relates to, you know, following through on your commitments when you say you're going to review offers at a certain time. But from a legal perspective, is there, if a listing agent says, hey, here's the deadline, but we might review them early if we feel like it, is there any legal concerns related to that?
I think so long as you are clearly communicating what may happen and how the seller will approach review of offers, I think it's, you know, perfectly acceptable. Whether it's a good business model or whether it's, you know, good strategy is perhaps a different conversation. I think that certainly it could discourage buyers from making offers in the first place, which quite frankly could hurt your seller, because maybe your seller is missing out on offers from potential buyers that may exceed what they're receiving. And so it could discourage additional offers, which may not be to the benefit of your client, but certainly understand why some brokers and their sellers are, including that language. But again, from a legal standpoint, it is disclosing the right that, they have to accept an offer beforehand, and it's not misleading from what I see.
Great. Yeah. Thanks, Janet. Now, a couple of people are mentioning in the chat here that at a minimum that the listing broker should provide the broker with a copy of the page of the ORF sale agreement, lines 504, 505, or which I think is on page 11. And we know, I think, that's an ideal scenario. But in a situation where a seller receives 20, 30 offers and the seller says, hey, I don't want to sign, all of these, what is it required that page be returned to a buyer?
No. So a seller doesn't have an obligation to formally reject offers, which I assume most of you know and have experienced over the years. So the seller doesn't have that obligation. However, I think it's very helpful for brokers to encourage their clients to formally reject offers because it is nice to close the loop and document things properly, and to formally inform the buyer whose offer was rejected of that rejection. I think it's appropriate. Not all sellers are going to do that, and certainly if they're being presented with 30 offers, they may not be feeling real inclined to do that. If the seller is rejecting an offer formally by signing the sale agreement, particularly the page in which they're rejecting it, if they're going to that trouble, certainly I would suggest providing the full sale agreement as part of that, because you would have received that, and turning that over to the buyer's broker would be appropriate, if not arguably required under licensing laws. And so if they're going to that trouble, you provide the full copy of the rejected sale agreement as part of that, and then you certainly retain it in your file for purposes of complying with your obligations under, again, state licensing laws.
Great. Thanks for clarifying that, Janet. So I want to move on from the offer presentation issues, and let's talk about escalation clauses, which we know are really a hot topic right now, and we're seeing a lot more of these in this market. So first, I'll remind everyone what we're talking about here. This is a clause from a buyer in their offer that states that the buyer will pay up to a certain amount more than the highest competing offer. Sometimes this clause will include a cap of the maximum amount that the buyer is willing to pay. So my first question, Deborah, for you is, from a buyer's perspective, do you think that these clauses are helpful?
That's a tough one, because for years I have not been a fan of acceleration clauses because I do have a concern that you're playing your buyer's full hand right up front. So again, if you're going to use acceleration clauses, they're perfectly legal in Oregon, and a lot of people are using them with great success. But I would just be a little concerned about them. Janet, what is your opinion on that as far as the acceleration clauses? And one of the things that I'm seeing and I get calls on is where a seller's receiving multiple acceleration clauses and trying to do the math and trying to figure out, oh my, when you've got competing acceleration clauses, there's the real potential for making a mathematical mistake just in trying to figure out what is the best offer based on competing acceleration clauses. So I think that in and of itself presents a challenge for listing agents when they're receiving those acceleration clauses. Janet?
Yeah. So a few things. I think they have worked, and they do work. I think from a psychological standpoint for the seller, it can feel, it can be very appealing. And it does have the potential to work. There are, we don't have a statewide form, but in Washington, Northwest MLS has a form for escalation offers, and I think it's pretty widely used. There are some problems. Number one, what happens if the escalation clause is not very well drafted, and it could lead to because we don't have a statewide form that's being used, it could lead to a disagreement between the parties as to how you escalate. Are you escalating based on gross sale price or on net, sale price net of seller concessions, for instance? What type of evidence does the seller need to provide to the buyer in order to escalate? And how does it work from a practical standpoint? Then you get into the issue of competing escalation offers and the concern that, number one, you may not be able to calculate an escalation price based on competing escalation offers, depending on how they're drafted. So it really can create confusion. It also can create quite a bit of risk for you as the broker who may be doing the calculation, and there's room for error. The other thing that comes to mind with respect to the risks are, what if you are perhaps representing two different buyers who are making an offer on the same property, and one of your buyers uses an escalation clause that is escalated perhaps based off of your other buyer client's offer. And that's hugely problematic. And from my standpoint, you have to be very careful when you are acting as a disclosed limited agent, either representing two buyers vying for the same property, or acting as a listing broker and then making an offer on behalf of one of your buyers. And this is true in any context, but certainly becomes more so the case when we are talking about escalation offers, because they can create additional risk and arguably could result in a dispute with one of your clients who perhaps isn't using an escalation offer and feels as though you didn't do a very good job explaining the different options that may be available to them. The other thing that comes up, and this is something from a business standpoint, something that Deborah had alluded to, which is when you are making an offer and using an escalation clause with a cap, that many times will result, not surprisingly, result in the seller simply countering at the cap, because it discloses to the seller that your buyer is at least willing to pay up to the cap, if not perhaps more than that. And so it's tricky, because you may be, by submitting an escalation clause and trying to gain an advantage over other buyers, it may just result in your client paying more than they otherwise would have needed to. So that's something to be aware of. I do not recommend making escalation offers with no cap, on the other hand, because it really could create a lot of problems. And over the years, we've seen that happen. It increases a temptation on the part of a seller to perhaps have a straw buyer come in and make an offer. Don't see a lot of that, but we have seen it over the years, and it's hugely problematic. I think the best strategy for buyers, even though escalation clauses can work, is simply submitting your highest and best offer and hoping that works. It's a cleaner strategy. It has less risk attached to it. It's much easier for the seller to understand. Everyone knows what the dollar amount is. It doesn't leave room for error.
Exactly. I totally agree. Highest and best, and have that conversation with your buyer. What is their level of investment that they're willing to make at this point in time for that particular property?
And going back to something we were talking about earlier, educating your client, and when you're meeting with a buyer, for instance, and talking about the different options available to them, this is an option that's available to them. So I think it's important to discuss this option with your buyer client and let them know that this is a strategy that's used by some buyers, and you can tell them why you recommend it or don't recommend it, and let them make a decision as to whether they want to utilize that strategy. The last thing you want to have happen is to not share this information with the buyer, and then they hear from somebody else about the possibility of an escalation offer, and they perhaps doubt your expertise. or alternatively, they lose out because of an escalation offer, and maybe their offer was the one that escalated somebody else's price, and they hear it through, through some other source that was the case, and they're going to be very unhappy about it. So you want to make sure that they understand that that's a tool, that it has some risks that go along with it. It's not a clean, foolproof tool by any means, but it is technically available to them, and they can make an educated decision as to whether to incorporate that type of clause in their offer.
And it's their decision, you guys. But that's, I think what we want to remember here is that the client is driving the bus, not us, and that we're simply facilitating the buyer and or the seller's decisions. So I get a lot of calls about, I don't even know if the other agent actually is talking to the seller, or if they're just making this up as they go. So, just remember that you're not a principal to the transaction, and that the buyer makes the decisions on what they're going to offer and how they're going to strategize, and the seller reversely makes the decisions on how they're going to negotiate it. And I'm in Florida, and there's a major thunderstorm happening. So if you're hearing the boom, that's what's happening.
Now I've seen, a few questions in the chat about, suggested language for escalation clauses and such. As Janet mentioned, Washington State does have a form, but even then I think it's controversial up there in the sense that a lot of people think these clauses are a bad idea to begin with, and even with best efforts, you can have some struggles in, agreeing on a specific price term. So while there isn't an OREF form on this, and there's one in Washington, even then it raises some concerns. In terms of sample language, we don't have any on our website. We do have some tips on our website, and again, we'll put in the chat our link to our section on dealing with multiple offer situations, where we offer suggestions on these types of topics. I do know there are some other suggestions out there. I think Online Ed has some posts related to some suggestions, but I would recommend, be worthwhile investment, meeting with an attorney and kind of getting your language. If you're going to use these, get it down, and then you could use similar language in the future. But taking the time up front to get the language down that you're most comfortable with, and that will best lead to the outcome you're looking for.
Right.
Now,
And something that comes up.
Go
Go ahead. Okay.
No,
Something
I
that
was just
comes
gonna
up.
make sure.
You go.
You go. No, you go. One of the things that you want to make sure of, though, is if you're using any language, that you've cleared it with your principal broker and your company legal counsel. You don't want to be practicing law by writing language, and so make sure you're running it by your principal broker.
Yeah. And that was where I was heading. Making sure, the concern I have when there's not a form commonly available to brokers is that it puts brokers into a position of potentially going out and drafting their own forms, and you could potentially have an office of brokers who all are using different language that may not be approved. So this kind of falls back on managing principal brokers to have strong leadership, strong education in their offices, to make sure that their brokers are coming to them to talk to them about these circumstances, and that they perhaps have policies or tools available so that you don't have each individual broker trying to draft their own escalation clauses. And we've seen all kinds of tools that brokers were using over the years, and some of them were hugely risky, and maybe they weren't sharing that information with their managing principal broker, or the managing principal broker only saw it after the fact when they were reviewing documents, and it's very risky. And so making sure that on an office or brokerage wide level, you have discussions with brokers and make sure that there's some consistency in how these things are drafted, because you don't want to make an error, because that could fall back on you down the road should there be an unhappy landing by your client.
Thanks for that, Janet and Deborah. Now, quickly, from the seller's side, what are your top tips for responding to an escalation clause? Janet, you want to take a stab?
Mhm. Well, I think the conversation, and this gets back to the education, the upfront education with your client at the time of taking a listing, is talking to them about escalation clauses and the fact that, you know, they could be faced with one, and how would they like to deal with them. So, you know, one tool that's available is they could certainly accept an escalation offer and base the escalation off of another offer that's received, or they could choose to reject that offer if it's, you know, nowhere in the ballpark of what they want or what they're receiving from others. Perhaps the cap is too low, or alternatively, they could just counter at the cap or above the cap, and that certainly, you know, from what I see, a very common strategy, and it's certainly a lot cleaner, clearer. It doesn't have as many, you know, risks attached to it. And, you know, the buyer's already communicated that they're willing to pay at least up to the cap, if not more. And so that is one strategy that's available to your seller, having that discussion with them so that they are not surprised when they receive an escalation offer, and you're not having the conversation at the time it comes up when you're under a deadline. And so doing it up front is very important part of the education.
Great. Thanks, Janet. Deborah, anything you want to add on responding to escalation clause?
I would even go as far as providing the seller with a copy of an escalation clause that your company has approved. That is that so they can familiarize themselves with the concept. You know, I think the concept, despite the legal theory of it, I think the concept of it gets people like a little into like an auction mentality. And I think that's where we have to be very careful when we're using acceleration clauses. But again, with the seller providing them a copy of your company's approved form for that, and explaining to them that the one they get from another company may be different, but the concept is basically the same.
Great. Well, thank you both for that. Good discussion on escalation clauses. I know there's a lot more to discuss there, but we want to move on to some other topics. So what I want to talk about now is some of the strategies that buyers are considering as they're trying to stand out and compete in this market, and what some of the risks that are associated with some of those strategies. So, many buyers feel that in this market, they can't compete just on price and terms if they're competing against cash buyers and such. And so they feel that if the seller knew more about them and their situation personally, they could make a personal connection to improve their chances. So they send what we call love letters. Deborah, what's your advice about love letters, pictures, or any other communications from buyers that are including personal information?
Well, I think the Oregon legislature just answered that question for us. I've never been a huge fan of love letters that include any type of reference to a protected class, which would include photos and videos, unintended. And so I think we have to be very careful there. The legislature passed a bill. We will be seeing some guidance on that. I'm going to come off a little Pollyannish right now, but I think you all should be writing love letters to each other. And by that, I mean clarifying. For example, as a buyer's agent, when I'm presenting my offer, I should have a cover communication to that other agent listing out, you know, what the key terms are of the offer that I'm presenting to you on behalf of my client. Can you imagine, and many of you have been in this situation where you're getting 15 or 20 offers and you have to go through every single one of those to fill out your spreadsheet or whatever you're using as a tool. So on behalf of my client, if I've taken the time to set out, these are the important terms that Ms. Seller, you're going to need to consider, then I've helped that listing agent and I've set my offer apart by showing and talk about the property. If your buyer insists on writing a love letter, make sure that they're only talking about the property and not the people. You know, just rule of thumb, property, not people. If you keep it within that scope, you should be okay. Just, again, that's just a real simple, smart business idea in today's market. Be the heroes to each other, and you'll do much better.
Great, thanks, Deborah. And Janet, Deborah mentioned that legislature did pass a bill. Now, it doesn't go into effect till January 1,
January, right.
2022. But Janet, anything you want to mention about that bill?
Sure.
As Deborah mentioned, I assume that, and certainly will be involved, and I assume the real estate agency will be involved in developing more guidance before January 1. But yeah, any thoughts now on that?
Right. So House Bill 2550 was passed and signed into law, and it, like we said, goes into effect on January 1, and it addresses concerns regarding fair housing issues. And this has been a longtime concern of mine, both in how property is listed. It's important to describe the property, not who would want to buy the property, not the potential buyers, but the property itself, because the last thing you want is to start describing its proximity to a specific religious institution, that it's great for a family, that it has certain aspects of the property that would be a perfect fit for this type of buyer, and you find out that they're really kind of classifying the buyer based on protected classes. Are they a single individual? Is it based on family size, background, where they're from, sexual orientation, race, and the like? These are all hugely problematic, and that's so that's on the listing side and has always been a concern of mine. Love letters have also been a very strong concern because it's a tool that's being used by buyers. I understand why they're using them, but the buyers who fit into this kind of category of, that may be a desirable buyer to that seller. We are, a family of 4, and we've got 2 beautiful children, and we want our children to grow up in the home. And, I understand from an emotional standpoint why a seller might find certain letters appealing and why that might make them more certain buyers more desirable to them. They want, somebody who fits in with their community, somebody who's going to get along well with their neighbors, whatever the case may be. But this is not about sellers having a right to select buyers on the basis of who these buyers are, where their income comes from. And love letters really, have this potential to walk the seller down the path of engaging in a fair housing violation. And so, I've always had some pretty strong concerns about buyers using them and sellers reviewing them. And again, I know it's a tool that's been very useful for people. I recommend against using them because I think it's very difficult for sellers to, or for buyers to prepare them and only talk about the property without slipping in some other detail that could potentially communicate to the seller something about their family status or whatever else the case may be. Better to stay away from them. If it's something about the buyer's plans with the property, I suppose they could share that. I think it's still hugely risky. Obviously, they're currently legal. Fair housing violations are not legal, but love letters are legal and can be used all the way up until January 1st. I think now is a good time to start. If you have been using them historically, it's a good time to start perhaps doing away with that strategy and talking to clients about why it's a bad idea, and also talking to your seller clients about why it's a huge concern for them to review love letters and use those in making decisions about which offers to accept, because of the risk that they could have somebody making an offer using a love letter, and maybe that offer isn't accepted, and that buyer feels as though it wasn't accepted based on the protected class in which they are a part.
Okay, well, thank you both for the great words of wisdom and caution as it relates to the buyer love letters. And as I mentioned, I expect there will be quite a bit more guidance coming out related to the new law as it approaches. I know there are some questions in the chat, but we are short on time and we want to get to a few more topics. So I'm going to push ahead. And I want to ask you both about another, some other strategies that buyers are looking at to try to stand out in this market. And one thing that we're seeing a lot more of is waiver of contingencies. And so I want to first talk about inspection contingencies. And Deborah, if you could share your thoughts on this, is it ever a good idea to waive a inspection contingency? And how can realtors protect themselves and their clients if a buyer does want to waive an inspection contingency in order to improve the competitiveness of their offer?
I think it goes back to that risk reward first and foremost with the buyer, and making sure that it's their decision, and explain to them the difference between waiving inspections and waiving the inspection contingency. It's two different things. You can still have inspections, but not use them as a contingency in the contract. So make sure you're explaining that. And I would never, even in this market, recommend to a buyer that they do not get a home inspection, that it's their choice, their decision. I would explain to them the strategy is that you're competing with other offers who may be doing this, and have it be their decision. But and if they do decide to do a waiver of inspections, or an inspection contingency waiver, then I would simply make sure that you use some kind of written CYA for yourself and your company that the buyers have made the decision to waive the inspection. We actually have a form that we require our agents to use if the buyer is waiving the contingency, stating that they are doing that fully aware of the risks involved with waiving the inspections and the contingency, and have made their independent decision to move forward with those decisions to waive those contingencies. I think those waiving of contingencies for inspections are going to come back and bite us in the butt big time. As Janet said earlier, when these buyers start to say, well, I bought this house and now there's a leak and my agent made me, I've already heard those words being said out there, waive the contingencies. So again, buyer risk reward, and that's where the decision to do that has to be made.
Right. And one thing I would comment on, it is about education. And I think putting it into the context of what really the ultimate risk to the buyer is, either, one, they are the successful bidder on the property and they learn about, a big problem, a defect at the property after closing, and it's, hugely expensive, and they weren't aware that they would have to deal with that. That was not part of their, financial equation in purchasing the property. The second part of it is talking about earnest money, because really at the end of the day, what is the risk to the buyer during the transaction? The risk is that they lose their earnest money. And so let's say it's technically refundable earnest money, but they've waived the inspection contingency. They have a home inspection nonetheless, and they learn of a big problem. The risk to them is that they forfeit their earnest money, and they need to understand that that is a possibility, and that they have to be willing to take that risk. So if they've got $10,000 in earnest money and they walk away from the property because they learn of a big problem, but gave up their right to terminate based on the inspection, then they lose that $10,000. And if
Exactly.
if they have an appetite for that risk and they can, afford to lose those funds, then so be it. But they need to make a knowing and a waiver of these rights.
They need to make an informed decision as to what their risk is.
Yeah.
Well, hey, I want to it's 11:59 and we were only scheduled for an hour, but I think as predicted, this topic has got so much more to discuss. So I just wanted to check in with you because we want to be very respectful of everyone's time, but especially if you, Janet and Deborah. So just if we go for another 15 minutes, are you able to do that, or do you guys have a commitment you have to get to?
I can do 15 minutes additional.
I'm good for 15.
Okay, great. And everyone, of course, if you need to leave, you can leave, but please stay on if you're interested. We want to try to get through a little bit more. And I'm looking through the chat here, and a few questions. One person asked about how can a buyer waive an inspection without, or how can a buyer have an inspection without it being a contingency? And I'll just say that there are two separate concepts. One is the right to come onto the property and inspect the home, and the other is the ability to back out of the deal and get your earnest money back if something comes up in that inspection that you then use to get out of the deal. And so you can, in the OREF forum, say that you're waiving your inspection contingency, but still agree with the seller that they're going to let you on the property to do inspections.
Right, and that would have to be built in. They'd have to write that into the additional provisions section or on an addendum to the sale agreement, because the sale agreement does not accommodate this idea of a waiver of the inspection contingency, but still having a right to inspect. And so that would be something you'd have to build in, structure the offer around. But it's an important detail. If your client wants to have an offer, or excuse me, have an inspection done, but they've waived it, they won't have a right to go onto the property and conduct inspections unless it's part of the agreement between the parties.
Okay.
And Jeremy, can I add one quick thing here? When a buyer agrees to buy, quote, as is, that does not relieve the seller from disclosure of material facts. So the seller still has a responsibility to disclose those material facts, even if the buyer's waiving and is saying they're buying it as is, doesn't remove that responsibility.
Right. It's as is light.
Yeah. Yeah, exactly.
Great. Well, thanks for that. Good discussion. And Deborah, don't need to answer now. Someone asked if you were willing to share that CYA inspection language, but I'll let you can think about that. And if so, you can provide it to us. But
sure. I don't mind sharing.
So, okay, great. So we can work with Deborah on that. There was a question about waiving inspections on new construction. Any additional considerations related to that topic?
Okay, can I go back and say I don't mind sharing, but please don't use it unless your principal broker approves you using it.
Yeah, that's a good point.
That's a good one.
Any special considerations related to waiving inspections on new construction? That was a question here.
Well, I think it kind of depends on the circumstances, but certainly, you want your buyer, if it's new construction, if it's new construction and the home is being completed, on or before the closing date, then certainly they're going to need to inspect it, at least to ensure that it meets the, specifications of the build. But, do they have a whole home inspection? I think it's a very good idea for new construction. I think it's a good idea to have an inspection for any type of construction, old or new, regardless of waiver of a contingency. And I think, you can waive the contingency just the same as to any type of property, but still reserving the right to inspect is hugely important.
Yes.
Great. Thanks. So let's move on to, and that's fine, it's a good segue because this is where we're going anyways, and it's also the last comment in the chat is let's talk about the waiver of appraisal contingency. This is another strategy that buyers are using, and there's no standard form or contract language for appraisal contingency waivers or modifications. So Janet, let me start with you. What advice would you give to realtors who are trying to include such a clause in their agreement to either waive or modify the appraisal contingency?
I think, the advice is just the same as for any other waiver of a right, that there is risk attached to it. I think, that you have a conversation with the seller about this as well, if they're receiving these types of offers. So on the buyer side, of course, as with any other, waiver of inspection contingency and the like, making sure that they understand and appreciate the consequences of waiving the appraisal contingencies. So, are they coming up with cash to make up the difference? What are what are the different risks attached to this? Well, one, they could forfeit earnest money if they aren't able to make up the cash, or the appraisal doesn't work out and they're not able to actually purchase the property. Then that's the risk that they take on. So again, it's about educating them, making sure that they understand, they've received written information from you that just says that, as you know, this carries with it some risk. Should you have any questions or concerns about this, I strongly advise you to consult with a legal advisor or other advisor about this strategy. And you started out with, you've indicated that you would like to move forward and having me prepare an offer in which we waive an appraisal contingency. It's really, it's a different type of waiver, but it really has the same, carries with it the same risks as do any other waiver. And I think, getting to the seller side, I've seen waivers and these different kind of tools used by buyers to gain the seller's acceptance, and the buyers are sometimes using those tools with this expectation that they can later renegotiate certain terms. So maybe they're waiving an inspection contingency but not the appraisal, and they know that they're offering way above what the appraisal will come in at, and they figure, well, at least if I lock down a deal with the seller is going to be forced to deal with this one way or the other, because they're going to know that my appraisal is going to come in low. And I think I don't love that idea. There's some strategic reasons why it's used, but having a conversation with the seller about these tools, including the appraisal waiver, and what they could mean for the seller. What are the different circumstances that could present themselves based on a buyer waiving an appraisal contingency, so that they understand if they're faced with an offer in which that contingency is waived, they understand the consequences of that and what it really means. So again, upfront education with either your seller client or your buyer client, and making sure that they're talking to somebody else should they have strong concerns about the risks involved in that strategy.
I think it's also important, that there are two different things. The appraisal waiver, you're typically going to find in a cash,
right,
or where the lender's going to allow the appraisal waiver. And then you have the appraisal gap, which is where the buyer is saying, in the event the property does not appraise, I agree to bring cash for the difference to the table.
Right.
So, so two different things oftentimes combined, but, and make sure you put a gap or a cap, I'm sorry, on the gap, a cap on the gap. There we go.
Yeah.
So make sure you're capping that gap on the on an appraisal gap. But just remember there are two different things, and FHA, VA, most of those are not going to allow you to do an appraisal waiver.
Right. And that's true with many conventional lenders as well. And certainly,
yeah.
If a buyer is trying to incorporate waiver of an appraisal altogether, they need to make sure that that's even doable given the method of payment for the property. So if it's a cash deal, that's one thing, but if it's financed in any way, they certainly need to make sure that that's going to be acceptable to their lender, and it may very well not be.
Be in tight communication with that buyer's lender that you're working with.
Right.
Great. Well, great discussion. And I wish we could spend more time on it, because I know, and I see a lot of great questions in the chat. And one thing we'll promise to do is we're going to save the questions from the chat. I put that link into the page we have on guidance on multiple offers. We'll add an FAQ to that, and we will continue to populate that with answers to questions that have come up here. And we'll connect with Janet and Deborah to get their thoughts on those. And we may do another one of these sessions again soon on this particular
Part 2.
topic. Yeah, or 3 or 4. We'll see how long this market goes at the pace.
Yeah, I'm willing. Yeah, let's do it soon.
So in the few minutes we have left, I wanted to get to a couple more questions. So we've been asked many times over the last few months from buyer's agents who are just trying to figure out how to help a buyer in this market about whether or not it would ever be appropriate for a buyer who has an offer outstanding on one property to put an offer in on another property And I just wanted to get both of your takes on that particular question. Janet, do you want to give your thoughts?
Sure. So I have a problem with that. And the reason I do is because the sale agreement contains certain representations by the buyer that they have funds, the cash sufficient to move forward in the transaction. And if the buyer is only intending to purchase one property, and you are very well aware of that, but they're throwing offers out on a number of different properties at the same time with no intention of purchasing all of those properties, they are technically making a misrepresentation, and you as their broker are assisting them in that. So I take issue with that. I understand why it's done, but you know what happens if a buyer has two different offers accepted at the same time? They would be using a contingency, in bad faith, quite frankly, to terminate one of those transactions. And again, you would be assisting them in that. So it's hugely risky for your client, your buyer client, and also for you as a licensee, since you not only owe duties to your client, but you also owe duties to the other party to the transaction and the other broker in the transaction. And then, of course, from a professionalism standpoint, it is a small community. If people are aware that you're assisting clients and going out and making a bunch of offers when your client only intends to move forward with one of those properties, that's also problematic as well. And brokers could, in certain communities, catch wind of that and be telling their seller clients that that's something that you engage in. And it's problematic for a lot of reasons.
Thanks, Janet. Deborah, anything you want to add?
No, everything she said, I have agents all the time asking me if they can do that. My first response is no. And then they'll say, well, yeah, but my buyer is insisting that I use that strategy. And my response is, if your buyer is insisting, then they must disclose. If you're going to continue to represent them, then they must disclose to the seller that they are in fact making multiple offers on multiple properties, and that they reserve the right to have the final acceptance of which offer they have accepted by a seller, which in my opinion diminishes their negotiating position right out of the gate. Yeah. So again, not a good strategy. I would not recommend it. And if you have a buyer that insists on it, you might want to reconsider if this is a buyer that you want to risk your career on.
Yeah, exactly.
Saying.
Good advice. So, Janet, I wanted to ask you one more question in the time that we have, and that is related to a seller. So we're seeing rapid price escalation, and so we're seeing more situations where sellers are actually getting cold feet by the time they near closing because they've either received another offer or it's higher, or they think they could receive more money if it went back on the market, given how much prices have escalated in the meantime. So Janet, in the standard real estate sale agreements that folks are used to using, are there any legitimate reasons why a seller can back out of a transaction? And what are the remedies available to the buyer if the seller does unlawfully terminate an agreement?
Sure. So there are very limited circumstances under which a seller could terminate a transaction. One would be if the seller conditioned the sale on something, some occurrence, for instance, identifying replacement property, something along those lines, and they were unable to fulfill that term, then they may have a right to terminate. But that's something that they would have had to build into perhaps a counter offer to a buyer's offer to reserve that right. So something along those lines. The second thing that comes to mind is if the buyer is in breach of the agreement, the seller may have a right to terminate and effectively terminate the transaction. It's really considered perhaps terminated already through the buyer's breach, but the seller may have a right to move forward in that regard because they're not going to be obligated to continue in a transaction in which the other party is already in breach. For instance, buyer doesn't pay earnest money at all. And seller's not on the hook all the way until the closing date. And typically, if there is a breach by the other party, they would need to move very quickly in terminating the transaction so that they weren't deemed to have waived that breach. As far as the remedies available, so I certainly have seen and been involved in circumstances where a seller has terminated a transaction for whatever reason, change of heart, change of circumstances, receipt of a higher offer, and then they didn't have a right to technically terminate it under those circumstances. You know, the buyer does have some remedies available to them. So number one, you know, from the most simplistic level, getting their earnest money back. One step up from there, it's getting damages from the seller for the costs that the buyer has expended in reliance upon the seller's performance. And then really, you know, the last, you know, the highest level of this is a right on the buyer's part to potentially pursue a specific performance claim along with, you know, their damages against the seller to force the seller to sell the property to them, to comply with their, you know, agreement, their contractual agreement to sell the property to the buyer. Those claims do come up. They're not uncommon, and, you know, buyers can be successful in forcing the seller to comply with their contractual obligations through a specific performance claim. The sale agreement has dispute resolution provisions, as we all know, that dictate mediation and arbitration. And so both mediation and arbitration would have to be initiated in order for the specific performance claim to move forward, because it's not something that's within the jurisdiction of small claims court.
Thank you for that, Janet. It's 12:15 exactly, so nice job. And out of respect for everyone's time, I think we have to cut this off. I hate to do it because there's so much more, but we will be back on this topic. We'll save the chat. We will visit that website. We'll update it with new information based on your questions. And everybody, please give a big round of applause to our guests today, who were just masterful at this topic and hopefully really helped you in thinking through how to approach these tricky situations. So thanks everyone, and we will see you next time.
Great, thank you.
Thank you.
Bye.
Thank you all, and stay cool.
Thank you.
Thank you.
Thank you so much, Deborah.